Well, Mary-Claire, thank you very much for that kind introduction, which does me more than honour. And my thanks also to all of the organisers of this conference and the sponsoring institutions for inviting me to take part. It's a great honour to be here, and I'm particularly pleased to join in the tribute to Judge Charles Gonthier. I was very much struck by what Judge Jamal has just said about law being a team sport. Having sat on the 15-judge International Court of Justice for 9 years, and having a fair degree of experience in arbitration work with tribunals of 3 or 5, I can tell you that that is very much the case. It's not a subject that you can practice on your own. You have to persuade, you have to bring others round, you have to listen, and you have to be willing to change. And my subject this evening in Cambridge, is the changing role of international law in the global economy. And I think it's worth just noting how much international law has played a role in changing the global economy in the last 30 or so years. First, and perhaps most importantly, the WTO and its predecessor, the GATT, have helped us to move from an essentially bilateral system of economic relations to one that is truly global, and made possible the integrated global economy that has existed until very recently, but is now under threat. In addition to that, investor-state dispute settlement, which was unknown when I was a student back in the 1970s, has involved international law today to a far greater extent in the way in which transnational investment is carried out, and I think has made companies more willing to invest in other states than they would have been previously. And lastly, although the International Court of Justice has not generally been heavily involved in economic cases, its case law on boundary disputes, particularly maritime boundaries, has had enormous importance in terms of the distribution of resources and access to resources. And while I think it's always important not to allow the resource elements to blind us to the extent to which a boundary dispute is a much more emotional matter, a matter of attachment to the land, attachment to the waters around it. We should never lose sight of that, but the resource elements are also of enormous importance. And those judgments have effects that will roll down through the generations in terms of access to fishing, for example, access to mineral rights. Now, none of the developments I've mentioned have been without controversy. The global economy has led to protests at every G7 summit that I can remember. It has been responsible in part for accelerating the Rust Belt effect in many developed countries, whereby companies that were producing goods at a price that simply was not competitive with companies in other states have gone under. And that has been an intensely controversial development, which has helped to fuel, for example, in my own country, the Brexit mindset that globalization has simply led to a stealing of what are described as our jobs. There has been a reluctance, increasing in recent years, to accept third-party dispute resolution, and the sense that somehow this is foreigners interfering in a matter which we should sort out for ourselves. And there has been a challenge to the legitimacy, particularly of ISDS, but also of many other forms of international dispute settlement. Above all, we now have the challenge of sustainability and environmental change, and the suggestion that much of what was regarded in the recent past as great advances economically have actually been very deleterious to the future well-being of society. Now, to my mind, the focus today has to be on how we change the existing global economy and the law that sustains it to make it more sustainable and to make it possible to deal with climate change, but also to make it acceptable to those who are on the receiving end of it. And that is a wide variety of different interest groups. I think there is a triple challenge for us. how to manage the economy in such a way that it doesn't stunt development in poorer states. There's nothing that is more infuriating to my mind than hearing people in the well-heeled North talking about the importance of preventing development which pulls millions of people in the poorer part of the world out of poverty. It mustn't stunt development in the poorer states, but nor must it plunge the wealthier ones into recession. I remember once when I was visiting the southern USA, being passed by a pickup truck, doubtless with an automatic rifle hanging on the back. But the bumper sticker was what caught my eye. It was about the northern US, and it just said, "Let the bastards freeze in the dark." We cannot adopt a legal system which leaves people freezing in the dark. And recession in the wealthier countries is almost invariably going to rebound on the poorer ones as well. The second challenge is that we have to develop an economy that is sustainable, especially in environmental terms. We simply cannot go on as we are, assuming that resources are indefinite, or that another generation will come up with a solution. We are creating the problems, we must also create the solutions. And the third challenge, to my mind, is how do we do this in a way which is based on the rule of law, not a return to the pre-war system of bilateralism and retaliation, protectionism. Those who are attracted by protectionism should take a look at what happened in the 1930s, when we succeeded spectacularly in making what was already a bad recession infinitely worse and infinitely more damaging than it needed to be. Now, the key decisions here are political, and I think it's important that we as lawyers do not overestimate our own importance. The environment is not going to be saved by law or by lawyers. It's going to have to be saved by political will, by economic incentives. But that does not mean that law cannot play an important role in that. It is merely to say that we are not going to be able to do it on our own. And I think it is fool's gold to imagine that through litigation, through a kind of lawfare, as it's called in a different context, it is possible to save the planet. In my view, it is not. You may achieve some things that way, but the most important achievements are going to have to be in the form of developing a shared political will to move forward. Where lawyers play an important role there is that we can produce the machinery necessary to implement those political decisions. Some of that machinery will have to be invented as we go along, but much of it is there already. And I'd like to suggest that, again, there are three matters we need to focus on. The first is to make sure that our institutions of international law are ones that work well and that are capable of inspiring trust. And here I think we have to look very hard at the debate about legitimacy of international institutions, which has got very significantly worse than it has been in the very recent past. And one of the things I find very sad is that you have the same language being used about different aspects of the international legal system by people from different ends of the debate. So unelected foreigners sitting in secret courts deciding on the future of the economy is the great criticism of the investor-state dispute settlement system. But almost exactly the same language comes from a different end of the political spectrum in criticizing human rights decisions. And I think neither group is aware of the extent to which they lend a hammer to their political opponents to use on parts of the system that they would wish to defend. But having said that, we have to take steps to make sure that we do enhance that legitimacy. I'm a strong believer in respect of investor-state dispute settlement, in transparency. And it's frustrating to see how often, under existing rules, it's not possible to publish an award or to have members of the public present at a hearing should they wish to be there. although having just sat in a hearing in an unair-conditioned room in Paris in a temperature of 37 degrees, I wonder how many members of the public would last the course if they were to be put there. But the opponents of transparency are not all to be found on one side or other of that debate. In years of sitting as an arbitrator in investor-state dispute settlement cases, I would say that the opposition to publication has come almost equally from states as it has from corporations. It varies from case to case, but it is by no means entirely on one side of that debate. We need to look at how we can manage amicus briefs in the course of ISDS without allowing the matter to get out of hand and without harming due process by queuing up a large number of bodies on one side of the case to fight a single opponent on the other. And we need to grapple with what is one of the most difficult issues in terms of the representation, for example, of indigenous groups. That is not a problem, in my view, of investor-state dispute settlement alone. It is a problem of how we address a situation where a state and the institutions of that state do not represent adequately the entire population of that state. And that is a problem that cuts across the whole of international affairs, and it's not peculiar to one part of the system. The second thing is that we need to learn how to use the existing law to face these growing challenges. Now, we need new laws. There's no question about that. But new laws take time. They take time in a well-organized state like Canada. I was going to say, or the United Kingdom, but how far we qualify as well-organized just at the moment is an interesting debate. But they take even longer in international law. And you only have to look, for example, at how long many treaties have taken to negotiate and then to secure enough ratifications to make them truly viable. Now, I am not in favor of distorting the existing law, but I am in favor of looking at it in the light of all the circumstances as they stand today. So, for example, in looking at the concept of fair and equitable treatment and legitimate expectations in investor-state dispute settlement, we need to look at whether, for example, there could ever be a legitimate expectation that a state will not change its environmental protection or its labour standards or its protection of its indigenous population. A state might, of course, promise not to do certain things, but I think one has to assume that the concept of legitimate expectations is not an expectation of stasis for all time coming. At the same time, those who criticize investor-state dispute settlement should reflect on the extent to which, particularly in a democracy, it is often very attractive to a government to blame the foreigner and to try and shift the financial burden of what is being done onto those who have no votes. When I was preparing for this lecture, I read a recent attack on ISDS by a writer who said it discriminates in favor of the foreign investor and against the domestic company. Well, it certainly provides a remedy the domestic company may not have access to, but the domestic company will generally have access to a great many other remedies, political and otherwise, that may be closed to the foreigner. And lastly, I think lawyers need to look harder at how to make proper use of the science that comes before us. I sat in two very interesting environmental cases when I was in the International Court: the pulp mills dispute between Argentina and Uruguay, and the whaling case between Australia and Japan. And I wrote short separate opinions, which I very seldom do, on both of those. But one of the things that struck me most is the extent to which you need a proper dialogue between the lawyer and the scientist. And you need to understand the role that science can play and not get carried away. I voted with the majority in the whaling case, for example, not because I think that the whaling convention has developed into a ban on whaling, but because I thought that the case had simply not been made out by Japan, that its whaling program came within the scientific exception. that the convention permitted. I do not think we do each other any favors if we go too far. And as I see that the screen has now gone to a different whiteboard, this is probably a good sign for me to stop. Thank you very much. It's been a pleasure to join you.